Good morning, your lordship and learned councils. A very warm welcome to the 6th TGA virtual moot court competition conducted by Thomas George and Associate. I'm Anshika Jain and I will be acting as the court master throughout the session. It is my distinct honor to warmly and kind-heartedly welcome our esteemed judge for today's preliminary session, Advocate Harish Chaudhary. Sir is a junior associate at Thomas George and Associate, Hyderabad, where he has been practicing since July 2024. A graduate of New Law College, Bharatiya Vidyapeeth University, Pune, class of 2023, he is actively engaged in diverse litigation matters across judicial and quasi-judicial forums. He has experience representing clients before civil and criminal courts, consumer forums, and labor commission, as well as tribunals including DRT and NCLT. He has also represented the firm in various district courts across Telangana in both civil and criminal proceedings. His practice reflects a strong commitment to effective and advocacy diligent client representation. We are really pleased to have you here, Your Lordship, to adjudge this round. Before we proceed, I request all the participants to keep the camera on all throughout the proceeding and ensure that any technical issue be promptly communicated by the chat box. May it please your lordship, may I continue with the rules of the competition?
Yes, you please.
Much obliged, your lordship. The structure of the proceedings as follows. Counsel 1 and Counsel 2 from the appellant side, which is TG23, followed by Counsel 1 and Counsel 2 from respondent side, which is TG29. Each speaker shall speak for 15 minutes, subject to the extension granted by the judge. But I kindly and respectfully request your lordship not to grant any extra time due to scarcity of time from our end. Placards will be shown to indicate the remaining time at 3 minutes, 1 minute, and when the time is up. And the same will also be communicated in the chat box. Steady internet to be maintained by all the participants, and in case of some internet issue, only 5-minute grace period will be provided, subject to the judge's discretion. Participant to ensure that cameras are turned on all throughout the proceedings. Judgments referred in during the arguments can be screen shared as per judge's discretion. If it please your lordship, the court is in session and I wish all the best to all of the participants.
Thank you, Anshika. Yes, we can start now. The appellant can start their pleadings. Yes.
May it please this honorable court, the council seeks permission to address the bench as your lordship.
Yes, please.
May it please your lordship, the council appears on behalf of the appellant, EBC Bank, who is the financial creditor hearing. May it please your lordship, the corporate debtor hearing has consistently acknowledged liability, repeatedly proposed one-time settlements, and yet refused to honor them. What brings us here to this court is the respondent's attempt to convert its own repeated defaults into a shield by hiding behind procedural technicalities. Your Lordship, the law under the IBC is clear. When debt exists, when default is admitted, and when limitation stands preserved, through continuous acknowledgements, the doors of insolvency cannot be shut. At the very core of the appeal, a very straightforward question lies. Can a debtor who admits liability repeatedly evade insolvency which occurred way before the default? The IBC does not reward strategic default. It mandates resolution when a default exists. The appellant comes before this honorable court not to pursue a fresh grievance, but to enforce a right that has been continuously kept alive, acknowledged and actionable since 1st April 2014 by the respondents themselves. Your Lordship has jurisdiction under Section 62 of the IBC. The impugned NCLAT order raises substantial questions of law regarding the critical interplay of res judicata, limitation, and the admissibility of a Section 7 application under the Code. The appeal is well within limitation. If your lordships are satisfied with the jurisdiction established, the council would like to seek permission to move on with the statement of facts.
Yes.
Your lordship, the facts of the case are quite simple. The appellant sanctioned a loan of 500 crores, fully disbursed and expressly acknowledged by the respondents. The crucial date herein is 1st April 2014, when the respondent's account was classified as an NPA. This is the first conclusive, undisputed date of default. Thereafter, the respondents conduct speech for itself. It sent restructuring and OTS proposals in 2014 and from 2017 to 2022. Each proposal is a fresh acknowledgement of liability, unequivocally extending limitation under Section 18 of the Limitation Act. An OTS was sanctioned in 2020, but the respondent again failed to pay, resulting in its cancellation on 1st May 2020. The first Section 7 application, filed in 2022, was dismissed solely because it inadvertently adopted the 1st May 2020 cancellation date, which fell within the Section 10A suspension window. Furthermore, the second Section 7 application, filed in 2024, correctly relied on the original default of 2014, reserved through continuous acknowledgements. However, the Honorable NCLT and NCLAT erroneously dismissed it, holding that the appellant changed the default date and that the application was barred by res judicata. Your Lordship, the respondent's liability is admitted, continuous, and unrectified. The only dispute being manufactured is a technical objection designed to defeat a valid claim. If your lordships are well versed with the statement of facts, the council would seek permission to move on with the issues.
Yes, you please.
Much obliged. Your lordships, 4 pertinent questions of law arise before you, from which issues 1 and 4 will be dealt by me, the council, and issues 2 and 3 will be dealt by the co-council.
Yes.
Your lordship, issue 1 asks a very question that is very central to the application, whether a second Section 7 application is barred by law. Your lordships, the application is not barred because the second application arises from a distinct earlier contouring default and the earlier dismissal was never on merits. This argument is based on 3 prongs. Firstly, the second application is based on a different and independent cause of action. Secondly, continuous acknowledgements preserve and extend the cause of action. And thirdly, res judicata in this case does not apply since the earlier dismissal was never on merit. Your lordships, the 2014 default is completely outside the purview of Section 10A. Section 10A only protects default on or after 25th of March 2020. This honorable quote in the judgment of Ramesh Kani, if my researcher would like to present it on the screen, makes the position quite clear. Section 10A does not extinguish previously existing rights. It does not affect earlier existing default. The default of 21, therefore, has remained always actionable, does not come under 10A umbrella, forms a legally separate cause of action from the 2020 based application. The appellant has not changed the date of default whimsically. The appellant has correctly invoked the earliest continuous acknowledged default supported by all records. Furthermore, your lordship, the respondent's own conduct is dispositive. They have themselves acknowledged liabilities through OTS proposals from 2017 to 2021 and under Section 18 of the Limitation Act, and further being reaffirmed by precedents such as Vishal Jaiswal and Dena Bank. Every single communication by the respondent reaffirms their liability, revives the limitation period, and preserves the appellant's cause of action. If anyone has relied on shifting positions, it's the respondents themselves and not the appellant. Moving further, your lordship, Section 11 CPC applies only when a matter is finally heard and adjudicated. The first application's dismissal was solely because of Section 10E statutory bar. It did not decide any debt, default, limitation, or any substantive rights between the parties. This honorable court in Ebix, Singapore, and earlier in Shiodan Singh has empathetically held that dismissals based on statutory bars does not attract the doctrine of res judicata. IBC, your lordship, is not a court that rewards technical superiority. It is a court that enforces financial discipline. To let the respondents escape because the first petition was caught in the statutory suspension of 10A would defeat the very architecture of IBC. Issue 1, thus your lordship, stands entirely in the favor of the appellant. If your lordships are satisfied with the arguments presented in issue 1, the council would like to seek permission to move on to issue 4.
I have one question. There are various OTS mentioned. Why only the specific to, the 2021 which you have mentioned, the cause of action arise as per the OTS? Like why that OTS has been considered and not the previous OTS?
Your lordship, every OTS represents a distinct independent breach. 2014 NCA and 2020 OTS both constitute a separate juridical event capable of independently triggering on insolvency. Choosing a date of default is entirely the creditor's choice, and every OTS proposal revives the limitation, and every breach refreshes the limitation. This breach has been continuing from the 2014 date of default, and this has been and this is the earliest actionable and uncured date of default.
Okay. So you can proceed with your issue number 2.
First obligation. Issue 4, whether admission or filed under the date of your lordships under section 7. What matters is the existence of debt and default, and not the precision of the date period. Your lordships, my argument is based on 3. First, section 7(5)(a) makes admission mandatory once default is established. Secondly, a mistaken date is a curable default and no defect, and no prejudice is caused to the respondent. Thirdly, continuous default since 2014 makes the exact period date irrelevant. Your lordships, this honorable court in innovative interest has made the law quite first. Insolvency admission is a summary process. Secondly, what the court must see is the existence of a debt and the existence of a default, and not the technical perfection in pleading. Your lordships, what the respondents are seeking is not refuge in law, but in loophole. Section 7 nowhere mandates that the exact date of default must be without error. What matters is whether the default exists. And error, it is not just established, but established repeatedly by the respondents themselves. Your lordships, moving further, the NCLAT in Credbook Advisors has held that even an incorrect date does not vitiate proceedings unless the debtor shows prejudice. The respondent here admits the loan, admits the dues, admits the inability to pay, and proposes settlements after settlement. A party that acknowledges liability for 9 years cannot claim it is prejudiced by a date description made earlier. Your lordships, the respondent may lie, but the acknowledgements do not lie. Moving further, your lordships, the respondent has been an unbroken default since the NPA classification on 1st April 2014. This honorable court in Vishal Jaiswal has held that continuous acknowledgements revive the limitation.
From Thomas George.
Thus, even assuming arguendo, a prior date was incorrect, the substantive default is clear, admitted, continuous, and well within limitation. A minor procedural irregularity cannot negate a substantively valid claim, especially under a remedial statute. Issue 4 also stands firmly with the applicant. Your lordships, the respondent has admitted its liability for 9 years, defaulted each time, and now it seeks refuge solely rooted in technicality. The IBC does not protect strategic default. It mandates resolution where debt and default exist. The council therefore submits that the impugned orders be set aside and the Section 7 application shall be admitted forth. If your lordships are satisfied with the arguments presented in this issue, the council would like to pass on the baton to my co-counsel.
I have one question for you. You filed this appeal before this court as per what section? Under what section you refer this as you filed this appeal?
Your lordship, section 2 of the IBC code,
No, I mean you filed before this court. filed before the Supreme Court under civil appeal.
Just give me a second.
So, you file a civil appeal before Supreme Court. Under what section you have filed?
Your Lordship, Section 2 of the IPC.
Okay.
Section 62 of the IPC. My apologies. Section 262 of the IPC.
Yes. The speaker too can proceed with their issues.
Indeed, Your Lordship.
Yes, speaker too.
Counsel seeks permission to take up the diet.
Yes, you can proceed.
Much obliged. If the bench is satisfied with the arguments presented by my co-counsel, then counsel seeks permission to proceed with the
Yes.
issue 2. Much
Yes.
obliged. Your Lordship, the counsel for the appellant respectfully submit that the court does not impose a right. It is a mandatory requirement for the pleading of an exact date of default. This insistence on specificity overlooks the objective of the code. What the law fundamentally requires is not an insistence upon the rigidity of a particular date, but rather the proof of default, which must satisfy the adjudicating authority on the existence of debt and its non-payment. As, firstly, the key provision, Section 75A, is unambiguous. It states that once the adjudicating authority is satisfied that the default occurred, the admission is mandatory. As also contended by the respondents themselves. Therefore, an application is fully maintainable, and the NCLAT and NCLT is dismissing it based on mere procedural inconsistency in the date. If your Lordship is satisfied with the arguments presented for issue 2, counsel seeks permission to proceed with issue 3.
Yes, you may proceed.
Your Lordship, the counsel submits with conviction that the correct and legally operative date in cases involving financial creditors and banking transactions is the date on which the account was classified as NPA. In the present case, this date is 1st of April 2014. The respondents attempt to assert that the 2020 OTS failure as the sole operative date is the deliberate and a transparent attempt to manipulate the timeline and circumvent the statutory bar. The appellant maintains that the date of NPA is the appropriate date of breach, which constitutes a continuous default. As, firstly, NPA classification reflects a legal moment of default under Section 312 of IBC. The determination of default is guided by the code itself. Section 312 defines the default as the non-payment of debt when due and payable. Statutory recognition. This account is classified as NPA only after the debtor has failed to service the debt within the required time. This NPA classification captures the precise legal moment when the corporate debtor has ceased to discharge its obligations. The Honorable Court in the case of Lakshmipat Surana reaffirmed that the financial creditor has a cause of action when the moment the debt remains unpaid, and the NPA classification is a statutory recognition of that non-payment. Therefore, in the present case, the date 1st of April 2014 is the legally correct date, as it is the moment the debt became due and was not paid, leading to the NPA classification. Secondly, as NPA initiates a continuous and unbroken state of default, the NPA date is not merely a single and isolated event. It is the point of crystallization that triggers a continuous and unbroken state of default. Once an account becomes the NPA, the entire outstanding amount becomes due immediately. The default becomes continuous and the cause of action persists until the debt is fully cured. In this matter, the debt default and the debt was never fully cured. The Honorable NCLAT in Milind Kashiram Jadhav v. SBI held that the date of NPA classification is the valid date of default for initiating CIRP under Section 7, and this date supersedes any subsequent events. Subsequent events, be it OTS negotiation or part payments, do not shift the original default date. They may serve to extend the limitation through Section 18 acknowledgements, but they do not create a fresh or an alternative default. The OTS negotiations and the subsequent failure in 2020 were not the creation of a new default, but merely the failure to cure the original continuous default that commenced in 2014. The respondent has remained in default from 2014 onwards and repeatedly acknowledged the same up to 2022. The default, therefore, is continuous, unbroken, and firmly established from the NPA date. The appellant's reversion to 2014 date is not a strategic alteration. It is the legitimate correction to rely on the legally accurate, the earliest date of default, which is clearly outside the scope of 10A. Your Lordship, if you're satisfied with the arguments presented for issue number 3, counsel seeks permission to proceed to prayer.
I have a question that what is the purpose of Section 10A and when it was introduced? Like when it was came into scope?
Your Lordship, Section 10A was implemented in 2020 due to the fact that there were several difficulties faced by the corporate debtors and financial creditor during a difficult time of COVID. And as per this section, it mandates that no filing of CIRP be undertaken during the time period of 25th of March 2020 to 2021, 6 months. And as per this section, the 10A application cannot be filed for initiating the CIRP against a corporate debtor.
Yes, you may proceed.
Therefore, in the light of facts stated, issues raised and authorities cited, and arguments advanced, the counsel for the appellant respectfully requests the Honorable Supreme Court to judge hold that the second application under Section 7 of IBC is maintainable and not barred by 10A or res judicata, declare that the precise pleading of the default date is not mandatory and that default stands proved on the material placed on record, affirm that the date of NPA classification is 1st of April 2014 and is the valid operative date of default. Hold that the application is admissible despite the earlier error, since debt and default and limitation are duly established. Set aside the impugned orders of NCLT and NCLAT and direct admission of the appellant Section 7 application, initiating the CIRP against the respondent, award cost and pass any further order deemed fit in the interest of justice, equity, and good conscience, all of which is most humbly prayed.
Yes. So, team 29.
Yes, sir.
Yes, you may proceed.
The
Speaker.
I'm speaker 1. May I continue? Am
Yes,
I audible?
I think the
So 1 minute. Can I get a 1 minute?
there is some echo.
Am I audible right now?
Yes. Perfect.
May I proceed?
Yes, you.
The council seek permission to address the bench as your lordship.
Yes.
This is Counsel 1 appearing on behalf of the respondent in the instant case of ABC Bank versus XYZ Private Limited, where I represent the respondent, the private XYZ Private Limited Company. Council 1 shall be dealing with issue 1 and 2, which essentially focuses on mainly two issues raised. One, whether or not a second application under Section 7 is barred by law. Two, whether or not mentioning of date of default is mandatory in application under IBC and shall be addressing the bench for a total of 15 minutes. Now, Council 2 shall be dealing with 3 and 4 issue that essentially focuses on the date of default that can be changed based on facts and circumstance or is to be taken as a date of default in all matters, in all the bank matters. Fourth issue will be whether or not a case can be admitted in the default occurred and the application is within the limitation despite an error in the date of default. Now, if your lordship is well versed with the summary of issues, the council seek permission to continue with the state summary of facts.
Yes.
So, if your lordship, may I proceed?
Yes, please. You can.
ABC Bank was a financial creditor who have arranged credit facilities for individuals and companies in the Union of Indigo. Whereas the ABC Bank have sanctioned loan facilities of 500 crores to XYZ private limited company under Companies Act and started business activities including in the energy sectors. So the loan account was classified NPA due to the inability of respondent inability of the respondents to pay repayment obligation on 1st April 2040. Later, due to default, the multiple letters issued by corporate debtor requesting restructuring and OTS to manage the loan liabilities from 2014 to 2020. Financial creditor have sanctioned later in 2020 to agree for a agree for the OTS. I have sanctioned the OTS letter, expecting to be repaid the whole amount by 31st March 2020. Since it was during the COVID period, a lot of banks and companies, and individuals were suffering to unable to repay the during this period to repay the loan amount. So the Union of Indigo, the government of Union of Indigo have approached with the new law that will help the companies and individuals to repay their amount, where the new law under IBC have brought section 10A to suspend new application for initiation of CIRP. That is where the creditors are restricted from for a temporary bar to apply for any CIRP for not repayment of loan. So here the financial creditor here filed a section 7 of IBC application before the NCLT against corporate debtor on 1st May 2000 on the default date as 1st May 2020 on 1st February 2022. Both the NCLT and the NCLAT have dismissed the first application on the statutory bar of section 10A of IBC. Later, the financial creditor have approached the court again with with the date of default by altering the date of default to 1st April 2014, where NCLT and NCLAT have dismissed the case due to citing the res judicata principle and and have the creditor arbitrarily change the default date. Now, may I, with the Lordship's permission, may I proceed with the issue? Am I clear with the
Yes. I have one question.
Yes, sir.
What is the concept of res judicata?
The concept of res judicata is it's a finality of law, where the court, if a court have already It is to prevent the re-litigation of any already decided cases. For example, sir, can I give it an instance?
Yes.
Yeah. So if a case have already decided in the court, it cannot be again attempted to re-litigated in the court.
On the basis of what?
On the basis it is already decided by the court, and so that there is no double jeopardy or double repetition of so that there is no burden for the court and as well as for the corporate debtors.
Okay, under what section it has been mentioned?
Section 11 of CPC.
You may proceed further.
Okay. So the arguments that have been raised is first one, that the second application under section 7 is barred by law. So with the permission of the court, I'll be proceeding. May I?
Yes.
Okay. So that there is an application of ground of res judicata in the insolvency proceedings. Your Lordship may be pleased to dismiss the second application under section 7 as being barred by res judicata and constituting an abuse of process on the ground that defective default date is pleaded and hit by the statutory bar of section 10A and time barred by limitation act. So turning to the first sub-issue, it is humbly submitted before the Honorable Supreme Court that the second application under section 7 is barred by law on the ground of res judicata. The principle of res judicata is generally applied to prevent multiple attempts on same cause of action that have been finally decided by the adjudicating authority, which is applicable in the IBC proceeding along with. The principle prevent re-litigation of issue in section 7 of IBC to constitute whether a creditor can initiate simultaneous CIRP applications, but court have already affirmed in various cases that it can be initiated for distinct cause and duplication on identification fact is impermissible. That is, it can be initiated if there is a distinct cause, but not for any identical fact. So here, the first application for the application to the fact, it has been the dismissal of the first. The dismissal of the first default, that is 1st May 2020, is non-actionable. It was dismissed because it was non-actionable under statutory act of section 10A. But later, the financial creditor have approached the court with a second application where it has been where it has changed altered the date of default to evade the limitation of section 10A. It is also brought into the notice that it has satisfied all the ingredients of this res judicata, mainly the same parties, same cause of action, and it was also dismissed by the adjudicating authorities like NCLT and NCLAT. Hence, allowing a fresh application on the petitioner's whims to avoid the war is undermining the legal finality and the integrity of insolvency proceedings. These principles ensure that once a matter is conclusively decided, it cannot be re-litigated through changes in the pleading. Moving on to the second sub-issue, there is an operation of section 10A as a substantive bar preventing the initiation of CIRP. It's humbly submitted before the Honorable Court that operation of section 10A is not a temporary or procedural suspension, whereas it is a substantive bar that prevents the initiation of CIRP. The section 10A cannot act as a procedural suspension, as I mentioned, as it is a permanently extinguish the right to initiate CIRP for such default even post moratorium and in forever barred, as mentioned in the section 10A. It has also been mentioned that the intention of the provision is to bar initiation of any application for filing CIRP where default had occurred on or before 25 March 2020 for a period of 6 months or until it has been notified. In this very case, the act of change in date of default in second application is a collateral attack on statutory bar. Thus, the Supreme Court and the NCLAT held that once a creditor plead on section 10A bar default and suffer dismissal, they cannot refile on the same cause or by retroactively shifting the date. Your Lordship, permitting this would render the idea the shall ever be filed meaningless, as every 10A barred creditor could manipulate date and reopen CIRP. Moving on to the third sub-issue, that there is an abuse of process through...
I have a question.
Yes, sir.
Yes, I have a question.
Sure, sir.
Section 10A, it was implemented on 25th March 2020, and it ended up to till date. Up to what date?
Till March 25 of 2021, sir.
Okay. So, isn't the CIRP filed before NCLT?
Yes, sir, but it is...
when it is filed after the section 10A was not in effect.
Yes, sir, but the act has already been decided. That is the first default they have brought on is the same cause of action, same parties, as well as dismissed by the same authorities. So when it has already been a final adjudication, it cannot be relitigated just by altering the date of default, sir.
Yeah. You may proceed further.
Okay. So the third sub-issue is that there is an abuse of process through repeating the filing of the suit. It's humbly submitted before the Honorable Supreme Court that the refiling amount the abuse of process of law. Under section 151 of CPC, the court have inherent power and the duty to prevent abuse of its process by dismissing vexation or repetitive or malicious litigation on the same or similar cause of action. The repeated institution of proceeding on same similar cause of action after prior adjudication or rejection by the competent authority constitute an abuse of a process of law. In the landmark case called Dalit Singh versus State of UP, the Supreme Court condemned litigation who pollute the stream of justice through manipulation, suppression of fact, or mischievous tactics. Holding such litigation is unable to get relief from the case. This appeal is also implied in the IBC proceeding, whereas abuse mislead the very purpose of the code for quick and concise and certain resolution. In this case, the financial creditor files simultaneous application. Hello, sir.
Yes.
Yeah. Okay.
You
Sorry,
proceed.
there was a... Okay. Simultaneous application under section 7 after the first was demanded on ground of section 10A. Simply changing the default date to escape statutory bar is clear abuse of process. It relitigate a matter already finalized and causing unnecessary delay and burden to the corporate debtor and the court. So the council would like, and this also contravenes the public policy and principle finality. Thus, the council summarily requests the court to dismiss the appeal. Thus, the ingredient of application remains same, but the date of default was changed to remove statutory bar, which show attempt to bypass the earlier judicial decision and revive a time-barred claim and amount to abuse of process. If your lordship is satisfied with the argument, council would like to proceed with the second issue.
Yes.
The second issue, it is on whether is that it's humbly submitted that the appellant's second application under section 7 is barred by law, which is also defective for failing to address the mandatory need of date of default and impermissibly alter the date of default and constitute a malified abuse of process of law. This appeal lacks merit and is therefore requested to be dismissed. May I proceed with the submission, sir?
Yes.
Okay. Moving to the first sub-issue, may it please your lordship,
Turning to sub-issue 1, that the section 7(3)(a) mandates specifying date of default as an indispensable prerequisite for the maintainability of an application of ABC. Now, it is also read with the rule 4 of IBBI rule, where it is demanded applicant for a precise disclosure of exact date of default by filing before the adjudicating authority. The NCLT has also affirmed in the case of Raj Ratan Babul Agrawal versus Solaratex Indian Private Limited, the essentiality of date of default and considered to a mandatory statutory requirement. So, any failure of mentioning such date of default will be.
Time is up.
So, can I get an extension for completing?
No, we already are late. So
can I conclude
proceed.
within 1 minute, sir? If you allow.
Okay, proceed.
Okay, so it has been proved to the court that there is a mandatory requirement of date of default in the in the application. Also, it also determined the limitation period from the date of default, sir. So it is if to prove that there is a financial debt according to section 5(8) of IBC, it is required to determine the limitation act. And so Article 137 is read with the sections 238 of IBC, where it is given a 3-year limitation period, and if it is not within the limit, it is a dead debt. So if the debt cannot be due and payable. So even if there is a mere acknowledgement of debt, if it is after the debt period or the time limit, if it is have crossed the limitation period, then it has been considered to be if it is just an acknowledgement of debt, then it is not alone can be considered as a reason to be brought onto the case. So
yes. Your time is up.
May I, if your lordship is satisfied with the argument, the council seek permission to give pass on to the next council.
Yes. Speaker 2.
The council seeks permission to address the bench as your lordship.
Yes.
Much obliged. Co-counsel seeks permission to proceed with issue 3.
Yes, you.
Much obliged. The date of default cannot be changed. It cannot be equated with NPA. Your lordship, the NPA date cannot be taken as the date of default. The appellant has now attempted to treat the NPA date, which is April 1st of 2014, as the date of default. This approach is contrary to the RBI Master Circular. As under RBI norms, NPA classification is a consequence of default, not the default itself. The circular states that an account becomes NPA only after the borrower remains in default for 90 days. That is, default occurs first when the payment is missed. NPA classification occurs later after 90 days continuing default. Thus, NPA date is not the date of default. And taking it as default date is also contrary to section 3 clause 12 of IBC and binding precedents of this code. This code in Dhanabang versus Shivakumar Reddy.
Sorry for the interruption. I have one question. How you differentiate the NPA with date of default?
Indeed, your lordship, NPA date is NPA date is the date which comes after 90 days of the repayment of if the default occurs after 90 days of continuous default, a bank classifies an account as NPA, that is non-performing asset. So the date of default, if an payment is defaulted after 90 days of such default, the financial creditor can classify the account as NPA, that is non-performing asset, which is not generating income for the bank anymore.
Yes, you may proceed.
Much obliged, your lordship. This case in Dhanabang versus C. Shivakumar Reddy case, this court held that Default occurs on the date the debtor fails to pay, thus it becomes due. NPA classification is only a consequence of default, not the default itself. Similarly, in Lakshmipathy Surana versus Union of India case, the court held that the date of default precedes the NPA date by 90 days. The NPA is a prudential banking mechanism, not a trigger for limitation or IBC. In our case, the default, if at all, would have occurred 90 days prior to April 1st of 2014, meaning sometime in January 2004 or before. Even on their own case, the second application under the Section 7 is hopelessly time barred and cannot use the NPA date to push limitation window by 90 days. Hence, the appellant's reliance on NPA date is legally invalid. Moving on to the second sub-issue, changing the default date is not a right. Your Lordship, it shall not be a right in law for an applicant under Section 7 of the IBC to change the date of default. Before changing the date, the parties should consider whether it affects the maintainability of the main application and it cannot be changed based on the convenience of the parties. Additionally, an amendment of the pleadings cannot be allowed, which takes away the valuable defense available to the opposite party. In this case, changing date of default not only affect the maintainability of the suit but also takes away the valuable defense available to the corporate debtor. In Veranium Cloud Limited versus Rolta Private Limited case, the NCLT held that the date of default cannot be changed at the whims and fancies of the petitioner. Similarly, in Inakshi Sopti versus Starlight Systems case, it was held that no amendments is permitted if it deprives the opposite party of a valuable defense. Here in this case, the appellant first stated the default date as 1st of May 2020, which resulted in dismissal because of Section 10A bar. Now, in the second application, they suddenly claim April 1st of 2014, a complete new default date solely to avoid the previous rejection. The law does not permit such strategic shift of dates. Moving on to the next sub-issue, change in default date defeats the certainty principle of insolvency law. Your Lordship, insolvency law is built on three pillars: certainty, predictability, and finality. When the default date, the heart of cause of action is changed repeatedly, and thus the limitation becomes uncertain, debtor cannot prepare a defense, judicial determination loss finality, the entire time-bound system collapses. This court in Swiss Ribbon versus Union of India case emphasized that the IBC is a complete code designed for speedy and certain resolution. Allowing creditors to shift default dates destroys the certainty and renders the statute meaningless. In the present case, the appellant's inconsistent position shows there is no real default exists, and they are unaware of when the default occurs. Also, they are attempting to manipulate the statutory bar under Section 10A by changing the earlier mentioned date of default. The petitioner attempts to bypass statutory bars. The previously mentioned date was under the moratorium period imposed by the government and therefore rejected by the NCLT. The constant try to evade the Section 10A bar by changing dates defeats the very soul of certainty principle, and thus the petition is not maintainable. If your Lordship is well versed with the third issue, the council seeks permission to proceed with issue 4.
Yes.
Much obliged. The case cannot be admitted as a second application is a malified attempt to avoid judicial order. Your Lordship, date of default is a substantive and mandated trigger for limitation under IBC. Date of default is the crucial event that sets the limitation period in motion for applications under Section 7 of IBC. This court in BK Educational Services versus Parag Gupta case has clarified that limitation under IBC begins from the date of default, not from NPA, not from OTS, not from recall. In our case, the financial creditor initially mentioned the date of default as May 1st of 2020, which is dismissed on the grounds of Section 10A under IBC, which was later altered to NPA date, which is not the date of default, but a measure taken by banks after 3 months of the default, and thus any of the mentioned default dates would be enough to prove the date of default, and the financial creditor themselves does not have any sureness on the date of default. This change of date is a constant try to evade the Section 10A bar. Such strategic alteration of the default dates directly violates the letter and spirit of the limitation framework under the IBC, and thus it refrained the court from determining the limitation period. Moving on to the next sub-issue, the dismissal is due to inconsistent dates and earlier adjudication. Your Lordship, the NCLT and NCLAT dismissed the second application because there is no new fact that the original course of action remained the same. Only the default date is changed, while the earlier dismissal has already attained finality once the issue of default and maintainability was adjudicated in the first petition. The appellant could not in law seek to reopen or relitigate the matter by merely manipulating the pleaded date of default. In this case, there is no fresh course of action, rather a repeated attempt to bypass the earlier adjudication. The change in the date of default is a mere technical maneuver to overcome the section 10A bar from the initial petition which is already adjudicated. Relitigating the same course of action with the same inconsistency in date not only barred by the principle of res judicata but also a waste of court's time. Moving on to the next sub-issue, the debt which is already dead cannot be revived. Your Lordship, even if the appellant's on-period default date is considered, which is 1st April of 2014, the limitation expired in 2017. In terms of Section 238A of the IBC, read with Article 137 of the Limitation Act, a financial creditor must initiate proceedings within 3 years from the date of default. Any events that occurred thereafter, including the OTS proposals, are incapable of reviving a time-barred debt. Accordingly, since the default asserted by the appellant stood time-barred as early as 2017, any OTS proposals or communication issued thereafter, including those in 2018, 2021, 2022, are irrelevant and incapable of reviving a time-barred debt. And the second application under Section 7 was filed only in 2024. The underlying claim is conclusively barred by limitation. A debt that is legally dead cannot form the basis, and therefore the present application is wholly unsustainable. If your Lordship is satisfied with the arguments, the Council seeks permission to proceed with the prayer.
Yes.
Wherefore, in the lights of the facts stated, issues raised, authorities cited, arguments advanced, it is most humbly prayed before the Honorable Supreme Court of Indigo that it may be pleased to adjudge and declare that the second application filed by ABC Bank under Section 7 is barred by the law and is not maintainable before the Honorable Court on the grounds of res judicata, that the mentioning of the date of default is a mandatory statutory requirement, and the appellant's inconsistent and inaccurate pleadings of this date renders the application defective and non-maintainable, that the date of default cannot be altered to suit on the convenience of the applicant, nor can it be equated with the date of classification of the account as NPA, that the appellant's claim is barred by limitation, and or pass any other order, directions, or relief that this honorable court may deem fit in the interest of justice, equity, and good conscience, all of which is respectfully submitted for this act of kindness. The respondent shall duty bound forever pray.
Yes.
Thank you a lot, sir.
Yeah.
It's an honor to have you here. And thank you, team. Please wait at the waiting area.
Sir, do we get a round of rebuttals and sub-rebuttals?
No, it is not allowed for
Sorry.
preliminary rounds.
It's not.
Okay, thank you.
Please wait at the waiting area.